A business may be held in a trust, and a trustee may account for business activities separately. So I'm going to read right from our statute here in New York, the Estates, Powers, and Trust Law in regard to this matter. So, a trustee who conducts a business can determine that it's in the best interest of all beneficiaries to account separately for the business instead of accounting for it as part of the trust's general accounting records. The trustee may maintain separate accounting records for its transactions, whether or not its assets are segregated from other trust assets. So you have a business, the business is in trust, and that trustee can account for the business activities separately. So moving on, there is a separate account rule that works so that the trustee may determine the extent to which its net cash receipts must be retained for working capital, the acquisition or replacement of fixed assets, and other foreseeable needs of the business or activity, and the extent to which the remaining net cash receipts are accounted for as principal or income in the trust general accounting records. A number of activities can be accounted for separately. So you have retail, manufacturing, service, other traditional business activities, management of rental properties, farming activities, and so on. So extremely important to think about. Now, I help individuals with estate planning, and I can tell you people come to me with business interests and they have no planning in place. At that point, it is quite difficult to get basic estate planning documents done as well as a trust because they haven't really thought through these things and it really is a bit overwhelming. So I would say if you have a business, get going with those basic estate planning documents as soon as possible. I always say that we are on an estate planning spectrum and we go from good to better to best. We have to kind of build up our muscles as we move through this spectrum and realize what it takes to have certain jobs as far as being a trustee, an agent under a power of attorney, and so on. I wanted to also bring up a quote from Judge Radigan, who was on my podcast. And he said, "It is a right and a privilege given to individuals to select their fiduciaries, be they executors, trustees, guardians, and the like. An individual should give great thought to the party they appoint in the various fiduciary capacities. Very often, it would be a spouse or a child or other relative. One must give consideration as to whether that individual would work harmoniously with other individuals who have an interest in the estate. If it is anticipated that there will be problems, one should consider appointing a corporate fiduciary, such as a bank, to handle the estate in order to put in place one who would be impartial and avoid disharmony." Now, he was talking mostly about wills and setting up your executor nominations in your will, but take that to a trust, and especially a trust that holds business interests. That person is typically going to be different than the agent acting under your power of attorney, and also different than the executor that you have nominated in your will. But that can be a very good thing because you're then setting in place the right person for the job. And as well, you have this very beneficial statute that allows a trustee to account for business activities differently or separately than other assets that may be in the trust and make some other crucial decisions. So very important to plan. If you have business interests, get going. You don't want to be at crunch time and all of a sudden trying to really scramble and think of a plan. This is Ruth George with Ruth P. George Law, PLLC, Trust and Estate Attorney. This video, as with any video I do put out, is for educational purposes only. It does not establish an attorney-client relationship, and I hope to see you on another video.